Welcome everybody to the 6th Afronomicslaw webinar. This webinar is co-sponsored with our friends at UNCTAD, who I'll be introducing very shortly. We're delighted to be doing this with them. It's also co-sponsored by the academic institutions of the editors, Loyola University Chicago School of Law, Dalhousie University Schulich School of Law, the University of Aberdeen, and De Montfort University. So for our audience, just some logistical issues as we begin. We would appreciate if you could keep yourselves mute and if at all possible also with your cameras off so that we can give the bandwidth to the speaker so you can see them when they speak. You, of course, are welcome to pose questions to our speakers using the chat function. We hope to only go for no more than 1.5 hours. Our speakers, who I'll be introducing shortly, will initially speak for about 10 minutes and no more, and then thereafter we'll begin the interactive portion of this this webinar. And just before introducing them, of course, the context here in terms of the discussion about the reform of the international investment policy regime in Africa, just to note as a very, very preliminary opening sketch, the very many developments happening in that landscape in Africa, and in particular the Pan-African Investment Code that has been adopted by the African Union with its very ambitious goals of combining the traditional protections investors have with things such as sustainable development. Then we have, of course, coming very soon, we hear the investment protocol of the African Continental Free Trade area. And of course, there's been lots going on at the sub-regional level in the East African community and elsewhere around Africa. At the national level, very many interesting developments as well, which UNCTAD religiously tells us about all the time, and which our speakers will talk about. Some very interesting developments in some national jurisdictions, including in Tanzania, where they basically adopted the new international economic order as the launchpad for their investment regime. So lots happening. This webinar, therefore, is really consistent with the goals that Afronomicslaw has of centering these types of developments as the basis for a discussion in the broader discussions of the reform of international investment law going on elsewhere in UNCTAD. But our primary goal, as I said, is to sort of center the developments in Africa. So our speakers today, I will not introduce them at length since we want to spare most of the time that we have today for the discussions. I'll introduce them in the order in which they will speak, and then we will have our first speaker. So our first speaker is Yvan Rwananga, who is a consultant at UNCTAD. Our second speaker will be Ms. Patience Okala, a legal advisor at the Nigerian Investment Promotion Commission. Our third speaker will be Hamed El Kady, the investment policy advisor at UNCTAD. Our fourth speaker will be Roselyn Ngeno, the senior investment expert at the African Union Commission. And last but not least, another friend of ours, Professor Kidane of the Seattle University School of Law and the Addis Arbitration Group. So we have a great group of speakers. And now I turn the floor over to Yvan, our first speaker, for his first 10 minutes. So Yvan.
Yes, thank you very much, James, for this introduction. Before I delve into the substance of the matter, allow me to just quickly commend Afronomicslaw for co-organizing these discussions, which are very interesting and very topical, especially at at such a critical juncture. You just mentioned all the developments many African countries are in the process of implementing, the AFCFTA, and more importantly, a lot of countries are struggling to recover from the pandemic and its many devastating effects. One of which has been to seriously hamper the flow of foreign direct investment. So to get the discussions going, I am just going to start by giving you a sort of glimpse or picture of the current situation of the international investment policy landscapes. Basically, we'll be just giving you numbers on the current BITs. I'll look at this from a global perspective, and also from an African continental level. I'll look at what we call modern treaties versus old generation treaties, and I'll also have a look into the investment dispute situation. So to start with the numbers, there's currently about 2,900 BITs worldwide. Out of these 2,900, about 860 some involve an African country as a party. And to narrow it down even more, out of these 800 some, 173 are intra-African BITs, meaning that both parties to the treaty are African countries. So why is this something important to mention? This is important to keep in mind because this is the number of BITs that could potentially, or most likely will be affected or replaced by the investment protocol of the AFCFTA, which would actually, if we come to pass, would have the effect of putting in place a single investment framework for the entire continent. So there isn't, as you mentioned, there isn't much available or public information on this topic, but hopefully my panelist Roselyn will be able to tell us a bit more about this. So now just turning about, as I just mentioned, on the share of modern new treaties versus old generation treaties. By modern, I mean in very broad terms, those treaties that sort of adopt an approach, a balanced approach between state commitments and investors' rights. So those treaties currently account for roughly 11% of all global BITs, meaning that the rest, 90%, are old generation treaties. So if we, if to look at the African continental level, the proportions are also more or less similar, where among those intra-African BITs, roughly 12% are only modern or new generation treaties, and the rest is, the bulk is old generation treaties. So at nearly 90%, the share of old generation BITs remains alarmingly high, and this has several implications. For example, this explains the ever-growing number of investment disputes, as I'll talk about in a minute. Most of the disputes that we see now are based on these old generation treaties. So just to mention in passing here that in the reform that UNCTAD has been actively pushing for and advocating for, a lot of focus has been placing on modernizing these old generation treaties, as they are the ones that are still giving rise to these disputes, where countries can potentially be held liable for hundreds of millions, if not billions. So this is maybe something that Ahmed will speak on. So now turning to investment dispute situations. In this context, I'm only referring to treaty-based disputes. In 2019, the number of those disputes reached the landmark number of 1,000, and they currently stand at 1,023 disputes. So of these 1,000 disputes, 121 have been brought against African countries, and that is roughly about 11% of all global disputes. So I need to clarify here that these numbers do not really give the full picture, and this is for two reasons. The number one reason is these numbers, again, as I just mentioned, they only cover treaty-based disputes. We do not account for investment, contract-based disputes, but we do know that some of the biggest cases that have been brought against African countries have been based on investment contracts between investors and states, and there's still quite a number of them out there. Number two is, as you are all very much aware, investment arbitration remains very confidential, meaning that there are many cases that are not made public and can therefore not be accounted for. So this is just to say that the number of investment disputes globally, and then particularly those disputes against African countries, is actually much higher than than what can be counted for. So having said all this, I also just want to mention that the situation is not all entirely bleak. In the recent years, we have seen African countries taking a number of actions to reform their international investment policies, and this at several levels, mostly domestically, also at bilaterally or at regional levels, and then also using different approaches. The approaches in reforming these treaties obviously vary. Naturally, each country will choose an approach that is more suitable to its own development priorities or national realities or circumstances. But some of the approaches that we see more frequently include, for example, the elaboration of modern model BITs that place greater emphasis on sustainable development. We have seen a number of countries choose not to renew investment treaties or simply to just terminate them before their terms. These are just like a few examples. Other approaches also include the modification or amendment of those treaties, but those are approaches that we don't see as much. Again, as I just mentioned earlier, these are reforms. These reforms are efforts that are mostly taken at a domestic, sometimes bilateral, regional level. And I will conclude with this. I just want to say that the investment protocol is a sort of golden or a unique opportunity for African countries to move this process forward in a very harmonized manner. So with this, I conclude my very brief presentation, and then I yield the floor back to you, James.
Thank you very much, Yvan, for getting us started very well and giving us the lay of the land, as it were. And now we have our second speaker, Patience Okala, who is a legal advisor at the Nigerian Investment Promotion Commission. So welcome, Patience. We're delighted to have you here.
Thank you very much, James. And I'd like to just start by thanking Afronomics and UNCTAD for working on this and giving us an opportunity to share the work that we have done on the review and reform of Nigeria's investment treaty regime. Our treaty reform process started sometime in 2015. We're not one of those countries that have many ISDS cases, but we had one at the time. We started the process because it became clear to us that our developmental objectives were not matching the quality of investment that was coming in. And we thought that for us as Nigeria, it was important for us to attract what we call RIBS investments. It's an acronym, RIBS, meaning responsible, inclusive, balanced, beneficial, and sustainable investments. So the object of our review at the time was to attract RIBS investments, to promote our sustainable development objectives, to preserve our policy space, our right to regulate. We also thought it was important to balance the asymmetry in investors' rights and obligations, and of course, to establish some dispute prevention mechanisms and limit our exposure to ISDS. Shortly after that, we had this P&ID case that made it even more cogent for us to take those steps in reforming our treaty regime. What we did them in 3 different phases, which are also consistent with the phases that UNCTAD shares with the world as the best way to go with these reforms. We started in 2015 with developing a new model BIT as phase 1, and then phase 2 entailed the modernization of the existing stock of our old generation BITs. And of course, phase 3 was to ensure that we have a coherence at all levels of our legal framework for investment. In the remodeling of our BIT model, we looked at refining the definition of investment to make sure it covers only actual investment. For some who might be familiar with the process and ID case that the award against Nigeria recently that Nigeria is contesting, you find that it emanated from an investment that hadn't really established yet in Nigeria. So we wanted to be sure that we were covering actual investments. We also worked at circumscribing our FET clauses, circumscribing our national treatment, most favored nation, and then we inserted temporary safeguard measures for the transfer of funds. We deleted a number of things, principal among which is the pre-establishment provisions. And of course, we tried to insert provisions that would preserve our policy space, improve our investment facilitation dimension, of course, push our sustainable development objectives, and introduce mediation. We introduced a joint implementation committee that was to help with dispute prevention or dispute de-escalation, as it were, before ISDS. And we also inserted some safeguards to our ISDS regime, including exhaustion of local remedies, among others. We did this with an interministerial team. I work with the Nigerian Investment Promotion Commission, which is Nigeria's investment promotion agency. We did it in liaison with key economic ministries of government, including the Ministry of Industry, Trade and Investment, Ministry of Justice, Foreign Affairs, Finance, Central Bank, all ministries that actually have some bearing on it. The model BIT formed the basis for our negotiations of a BIT with the Kingdom of Morocco in 2016. And some of us might be very familiar with the provisions in that BIT. That BIT was featured in UNCTAD's 2017 World Investment Report as an exemplary BIT because of the modern provisions it had for other developing and emerging economies to emulate. Certain provisions of that model were also included in our BIT with Singapore. So that was phase 1. We had to move forward with the existing stock of BITs that we already had, some of which were already in force. Others were already concluded, but were not yet in force. And what we did was to draw inspiration from UNCTAD's World Investment Report of 2017, where there was some kind of mapping of the reform-oriented provisions of bilateral investment treaties for 2016. We expanded on the provisions that were used. We came up with what we call CROPs. We looked out for critical and reform-oriented provisions of our BITs and came up with 20 of such parameters. We mapped all our BITs on the basis of those 20 parameters, and what we found was outstanding, but it also showed us why we did not get the quality of investments that we required in Nigeria, despite the fact that we had signed a number of BITs. From that mapping exercise, it was clear that the provisions in our BITs were not representative of the quality of investments that we required to move our economy forward and to meet our national and developmental objectives. And based on that work, we went further to undertake a country-specific assessment of each of our BITs. And we came up with specific recommendations on how to move forward with all those BITs. So where we found gaps, we made recommendations as to renegotiation, as to amendment, or for those that were nearing termination, just to terminate them and start the process afresh. We have done that for all of Nigeria's BITs that we assessed. Moving on to phase 3 of the work that we had done. Phase 3 required a cohesion between the gains that we had made in phase 1 in the model BIT and of course with the existing stock of BITs to ensure that those gains and those reforms were replicated in our national investment law. Yvan had already mentioned that ISDS cases, international arbitration, stems from 3 sources. Stem from investment contracts, bilateral investment treaties, and of course investment laws. We found that in our national investment law, there were quite a number of investment protections available to investors. And we thought that a lot of them were open-ended. They did not have the safeguards that we had inserted into our bilateral investment treaties. So we thought it was important to create some kind of alignment between what we had done in our treaty regime and what we have done and what we had existing in our national law. And so we started the work of trying to amend our national law. That process is still ongoing. The process that we had done for our investment treaty regime and the reforms are things that our policy direction of government as it stands concerning investment promotion. And what we thought would be useful was to just use that as a launching pad as we began to engage in other multilateral negotiations across the world. Negotiations such as the UNCTAD Rules Amendment process, the work of UNCTAD Working Group 3 on reform of ISDS, and of course, the work that is currently ongoing in relation to the investment protocol of the AfCFTA. For the reform of our national investment law, we were looking only primarily at the key investment promotion, investment protection, and investment facilitation provisions to align them. One of the main things that we were also looking at, and we thought was novel in the course of our work in reviewing our treaty regime, was the introduction of this joint implementation committee. We thought that if we could help to de-escalate disputes and help to give investors some level of comfort, then disputes will not escalate to the point of ISDS. So one of the things we're also looking at is to replicate that in our national law by creating or establishing an investment ombudsman. We have found it to be very useful because on an administrative level, we had actually started some work within the Investment Promotion Agency to deal the disputes of investors at that level administratively, and we have recorded quite some success. So we're escalating it to the national law to see that we have that also replicated in our national law. In terms of next steps, it is the review of our existing BITs. It's not something we can do by ourselves. So we're taking preliminary steps to engage our treaty partners on a case-by-case basis. And then a new dimension that just featured that emanated from the COVID-19 challenge that we're all very familiar with is what happens with the prospect of ISDS cases emanating from measures that have been taken by our government, interventions taken by government in relation to COVID-19, and how investors could, take advantage of those measures and start ISDS cases. So in the past few months, we've been thinking, brainstorming and doing a lot of work on that. We've been doing some multilateral engagement, which I'm sure my friend Roselyn from the AU may speak on, but we're also working on seeing how the reform dovetails into our current reality. I will stop there, and I'll be very happy to take questions subsequently. Thank you.
Thank you so much, Patience. That was really a really excellent overview of the reform process in Nigeria, the justifications for it, the three phases, and two things that I'm really delighted that are already coming together, the importance of domestic law is sort of aligning eventually domestic law to the reform process, but also the context of COVID-19 in terms of anticipating what might or might not happen, especially with dispute settlement. I also like the fact that you sort of have also referred us to the connections between what Nigeria is doing and the reform processes at the multilateral level with the exit rules reform process and what's happening at UNCTAD Working Group 3. Our next speaker is Hamed El-Kady, the Investment Policy Advisor at UNCTAD. Hamed, the floor is yours now for the next 10 minutes before you get in trouble with B.
Okay, thank you very much, James and Afronomics. We are delighted to partner with you. We are very impressed with the quality of the publications and webinars you have been organizing lately, so congratulations to all of you. Just to, before starting, just maybe a few words on the global context with regards to foreign direct investment and COVID-19. Unfortunately, of course, there will be a huge impact on the flow of investment, as noted in our recently published World Investment Report. the virus or the pandemic will cause, we expect a fall of up to 40% from the 2019 value of 1.5 trillion approximately. We also note that although the impact is severe everywhere, that developing economies, and including Africa, of course, are expected to take the biggest hit, and that's because of reliance on global value chain intensive and extractive industries, which will be severely affected by the pandemic. Governments have been taking two kinds of measures to respond to the pandemic, two broad categories, if you wish. The first category or group of measures are the measures that aim at supporting foreign investors or investors in general by allowing for tax breaks or giving incentives and easing administrative obstacles, etc. The second group of measures that we see are the opposite of this, measures that are more of a restrictive nature, and these two kinds of measures are happening in parallel. The measures of restrictive nature are more geared towards the protection of public health, ensuring that there is enough medical supplies, and really going a little bit looking inward to ensure that this sector is protected. So these two things are happening in parallel, and it is in that context that this webinar and that discussions on the investment framework in Africa is extremely important. If there are a few things that African countries could do, and I have 5 points here. Number one is to recognize that there is, I wouldn't say potential, but there is a clear tension between the obligations found in international investment treaties. Mind you, the bulk of these treaties were signed 20, 30, sometimes 40 years ago. And these commitments are still in force today, binding or restricting the space of governments to respond to modern crises. Today is public health. Who knows which global crisis is going to come in the future, maybe relating to climate or any other public and global crisis. We have witnessed a rise of investor-state dispute cases during the financial crisis and during other global crises, whether at the international level or domestically. So the idea is to try to avoid that as much as possible. Now the solution or the recommendations are a little bit of a long-term solution, but they are worth it to start implementing it now. First, really, African countries should start by ensuring that there is an interministerial consultation or discussions among the various ministries within the governments that are dealing with different investment-related aspects. We see that there is a fragmented approach. You have sometimes one ministry dealing with free trade agreements, and trade has an investment component or an investment chapter in this agreement. You have another ministry that has the file of the bilateral investment treaty, and maybe communication between these two ministries are not how they should be when you are approaching negotiations with a third party. So discussion, consultation among the various ministries, including the Investment Promotion Agency, the Central Bank, the Ministry of Foreign Affairs, in order to form a coherent position when you negotiate with third countries. The second point, which was mentioned by my colleague and friend Patience, is really to conduct a review of your existing investment treaties. I think this is extremely important, is that countries to put their house in order before engaging in further negotiations. You look at your treaties, you analyze them, identify the provisions that are problematic today, and identify potential inconsistencies. And every country can do that now. A third step is to develop a new model, BIT, or a new model investment treaty that can be used for two things. Forward-looking, you use this new model after a domestic consultation process to negotiate new treaties, or you use this model to renegotiate and amend your existing old treaties. The fourth point is to go ahead and implement what is in your model, or try to reflect some of its provisions by way of renegotiating or amending your existing treaties to bring them in line with today's challenges, realities, including the state's efforts to achieve sustainable development objectives, for example. Finally, and the last point is to pay particular attention to what's happening at the continental level. I witness and I see sometimes that a lot is happening domestically at the national level. African countries are reviewing their treaties, are developing models, but then when the discussions becomes at the regional level or the continental level, the kind of momentum is a little bit slows down a little bit. And I think the African Continental FTA should, on the contrary, enhance and give momentum and push for a continental approach to investment policy making. And I think the opportunities that lies ahead of us are tremendous, and African countries should really look into that and reap the benefits of this regional protocol. Thank you very much, and I hope I kept my 10 minutes. I'm sorry if I did not.
Ahmed, I didn't want to suggest that you speed up, but that was really great.
Okay.
You have really set up our next speaker, Roselyn Ngeno, the Senior Investment Policy Expert at the African Union Commission, very well, because both you and Yvan have challenged, the African continent to have a sort of a coherent continental approach in the international investment regime. Like everybody else, I think you emphasize the importance of reform also at the domestic and the sub-regional, what I'll call the sub-regional level, the sort of sub-regional level, and then the continental or the regional level. So I think the conversation is really converging very well. And now to tell us how all this will work at the continental level is Roselyn Ngeno, and we are delighted to have you, Roselyn, and the floor is yours for 10 minutes. One more thing I wanted to say, Ahmed, I really appreciated your detailed step-by-step process by which countries could approach the reform process. And now we'll hear what the African Union is doing about all this.
Thank you very much. Chair or moderator, thank you for this opportunity to speak. We sincerely appreciate UNCTAD and Afronomicslaw for inviting AUC to be part of this important debate. You've heard from the previous speakers, and also particularly what Ahmed has said about the reform process and the advice that countries should take, particularly African countries should take, in terms of reforming their investment treaties to fit into their policy dimensions, but at the same time responding to what is happening internationally and regionally. Now, allow me to give you a background to the investment protocol. The Africa Continental Free Trade Area, which came into force in May 2019, encompasses decisions and commitments on market access and provisions to reduce barriers to trade and investment. It will help enhance competitiveness and promote industrial development, and as well as regional value chains, agriculture, and food security, if it is implemented effectively. With the need to create at least 13 million jobs per year in the continent. The accompanying architecture of the AFCFTA, and as outlined in Article 4 of the agreement, is to cooperate on investment, intellectual property rights, and competition policy. These are to be achieved through the AFCFTA Phase 2 negotiations. The discussions under this phase, unfortunately, has been delayed due to the current pandemic and also due to the need to put effort and focus on the conclusion of Phase 1 in order to facilitate start of trade under the AFCFTA, which has been scheduled for 1st January 2021, pushed from July 2020 due to the challenges that we are facing currently. The negotiation and conclusion of the Investment Sustainable Protocol under Phase 2, driven by the Voice of Africa, is expected to create a competitive and conducive business environment for foreign direct investments, as well as domestic direct investment throughout the continent. And this will be through a set of institutional arrangements that would guarantee the rule of law, enables entrepreneurial activities, and improves the security of property rights. This will ultimately play a positive role in attracting investment, as well as boosting the productive capacities of the existing enterprises. Now, due to the fact that the discussions by the member states on the investment protocol has not yet commenced, and Chair, you had mentioned a little bit about the Pan-African Investment Protocol, I must put a caveat that what I'm about to present are the ideas and suggestions that the Africa Union Commission has concerning the content or the envisaged content of the investment protocol, and not necessarily the position of the member states, although it draws from the reforms that countries have undertaken, including the guidance that UNCTAD has given to many African states. And I actually want to take this opportunity to really applaud the Nigeria Investment Agency for spearheading the reform of the investment treaty. It is envisaged that the investment protocol will be a progression of what African states have done in modernizing their domestic investment codes to protect investment with a view of balancing the country's development interest with those of investors, while affirming the sovereign right of states to regulate investments in the public interest. The content of the investment protocol will draw on this advancement, with the starting point being the Pan-African Investment Code, which is the first investment treaty model that the African Union has adopted in its history. The Pan-African Investment Code is a continental framework that puts the long-term goal of securing sustainable development at its core, visible right from the instrument's preamble, which makes sustainable development the primary objective of the code. The preamble of the Pan-African Investment Code also emphasizes the importance of the Sustainable Development Goals for the economic, social, and environmental development of the continent. Furthermore, the formulations in the Pan-African Investment Code include provisions safeguarding the right to regulate, the right to pursue development goals, exclusion of umbrella clauses, carve-outs, as well as provisions aimed at minimizing exposure to international arbitration. Most importantly, the Pan-African Investment Code sets forth the right of Africa Union member states to preserve their right to regulate and to open or close sectors to investment in accordance to their development strategies, which is always a very tricky policy decision for countries. This includes, for instance, that performance requirements may be imposed by states on foreign investors to ensure that their investments also benefit African host states at different social and economic levels. So by building upon the achievements of the Pan-African Investment Code, the process of the Sustainable Investment Protocol offers definitely a new momentum for the Africanization of the international investment regime, as has been written in some articles, including articles by Professor McCann. It also opens new economic windows to promote regional integration, to boost inter- and intra-African investment, to support regional industrialization and the development of cross-border value chains. The success of the protocol, however, will depend on identifying the key development objectives of all African countries and on formulating key provisions in the protocol that will be supportive to sustainable investment promotion and facilitation within the context of the African continent's developmental priorities. But most importantly, the success of the protocol will be measured on the basis of its ability to bring coherence and consistency in the constellation of highly innovative regional approaches and devices that have been put forward to build a sound and predictable investment regulatory framework across the continent. The protocol presents a unique opportunity for Africa to codify and harmonize all the existing and stimulating ideas and progressive innovations that are being brought across the continent with the aim of building a competitive continent for investors and investments. The protocol also envisages the possibility that it has the potential to solve the problems of legal uncertainty and inconsistency, as you had asked, moderator. In this respect, the African Union is determined to guide its member states to develop a protocol that speaks to their needs, including addressing the dynamic and ever-evolving character of the relationship between investors and the states, while recognizing the rights and obligations of the investment community and all other stakeholders. Allow me to stop here and thank you for your kind attention, and I'm ready to answer any question that you have. Thank you very much. Over to you.
Thank you so much, Roselyn. Ngeno, that was really great, and I appreciated your frank discussion about what you said being the envisaged reforms about a process that is yet to commence in terms of the negotiations of the AFCFTA's investment protocol in light of the pandemic. But many of the values that you mentioned that are at the center of the Pan-African Investment Code that you said are also part of the reform agendas we had in Nigeria: sustainable development, the right to regulate, exclusion of certain clauses like umbrella clauses, and minimizing exposure to investor-state dispute settlement. All those are common themes that we've had today. And I think that this conversation cannot end better in terms of the first 10 minutes of presentations, because the next speaker, Professor Yvan Kidane, has engaged these ideas by examining the Pan-African Investment Code, the debate about the Africanization, the debate. I don't want to set him up, but I see he's smiling, but I know that he has sort of very closely looked, for example, the Pan-African Investment Code to examine whether, for example, it imposes a higher level of obligations on African investors relative to obligations that investors from third-party countries may have. So, Professor Yvan Kidane, welcome to the conversation, and you have 10 minutes.
Thank you very much, Professor Gathii, and thanks for the invitation, Bisi, and all of you. So in the 10 minutes that I have, I'll try to address the initial question that I was asked about, to compare the efforts, the reform efforts that are underway in Africa with the UNCTAD Group 3 work, and also some of the questions that Professor Gathii just presented. So the African effort is a part of the continental free trade area, which is a creation of a common investment area also embedded in it. So conceptually, it's the harmonization of rules across Africa and creating that seamless flow of investment across these African countries. The starting point, however, is the fragmented bilateral investment treaties that are enforced and are also in effect across Africa, interlinking some of African countries with one another. From what is happening, I'm sorry, with the UNCTAD Group 3 reform efforts, the problems have been fairly well understood, and a number of proposals are being entertained. This pertains to both the clarity of the substantive obligations and the dispute resolution mechanisms. And the African reform effort has effectively inherited all of the problems of the existing framework, call it a system or a framework, and is trying to understand it and try to resolve it in a new way by creating a new intra-Africa legal infrastructure that is informed by previous deficiencies, is forward-looking, as we've just been told, and addresses some of the serious problems that have been affecting the system. There are at least two broadly classified two categories of problems that have been ailing the ISDS in the international investment regime, right? That is the lack of clarity of the substantive obligations. With that, there are two problems. First is the substantive standards are supposed to be external to each state. They are additional external obligations that a state undertakes vis-a-vis investors. And the second, obviously, is those external standards are not fairly well defined. An example of that is the fair and equitable treatment, for instance. The other major problem is the interpretation of these rules by ad hoc international arbitral tribunals. And these tribunals traditionally are ad hoc and unaccountable. In obviously judicial proceedings where there is possibility of appeals, there is some type of judicial discipline. Lack of that and lack of a coherent substantive regime made the whole thing problematic. So UNCTAD Group 3, when they're talking about reform, they're talking about all of these problems at the same time, and they are trying to address them incrementally, step by step. Do we need an appellate mechanism to provide discipline, consistency, and coherence in the jurisprudence? Do we need to define the substantive terms more clearly? Does the treaty need to provide interpretive tools? Things of that sort. They are being looked at very closely, including accountability, ethics, and things of that sort for arbitrators. So when the Africans are negotiating a protocol, they're talking about all of these things and trying to understand how we can minimize all of these problems of the existing regime, create a framework for the seamless integration of the common investment area within Africa. So the Pan-African Investment Code is an attempt to make sense of the existing reality, add some investor obligations, and also elaborate some of the existing principles. So as Professor Gathii mentioned, one of the problems that have been identified with that approach is its restrictive nature. It's a defensive posture that is informed by Africa's existing experience that hasn't been very pleasant for a variety of reasons, primarily because of the decision-making process. So coming from that background, it almost seems like African investors within Africa might be disfavored than investors from outside Africa if a defensive posture is what is leading the way in the Pan-African Investment Code. And then I'm sure going forward, the negotiation of the new protocol, a more balanced approach would emerge, which is the creation of a common investment area requires, at some point in the future, a plain playing field for investors across Africa. So there has been some discussion that we've heard this morning about Nigeria's effort in reforming its own domestic investment law. And whether it is through a series of reform of domestic systems or through harmonization treaty that trickles down, the objective, the ultimate objective is that a Nigerian investor in South Africa does not feel any different from a South African investor in South Africa and the vice versa. So to attain that level of harmonization and comfort for investments to move across Africa, a defensive posture of states' rights, investors' restrictions, that kind of approach traditionally has been to address all of these problems that Africa had to endure because of the imposition of external standard and lack of control on the decision-making front. So before I end, I'll just simply say that if the objective for Africa is the creation of a common investment area, all of these things need to be looked at very carefully. The idea being to have uniform substantive standards that are fairly intelligible and a decision-making process that is accountable. So making sure that the decision-making process is accountable. Many proposals are being floated. One idea is the investment court idea that I know it's not very popular in Africa. In Europe, it's very popular. But if Africa wants to go in the direction of continuing ad hoc decision-making by arbitral tribunals, that's another option. But I want to say one thing, the investment ISDS system is actually designed on the basis of commercial arbitration. Commercial arbitration, as Justice Stevens says in the Mitsubishi v. Solar case 1984, I think, he calls it arbitral decision-making as despotic decision-making that may be acceptable to businessmen because all they want to say is, oh, they've resolved their dispute, then you move on to the next business adventure. That has not served investor state very well because of policy implications, public interest, and all of that. So that model has been tried for the last 50 years, and perhaps it might be time to actually closely examine how to bring about accountability in decision-making. To me, more serious problem is the decision-making, the procedural problem than the substantive rules. And I don't see any problem in fair and equitable treatment by its very essence. It's these tribunals who interpret fair and equitable treatment to mean legitimate expectations and whatnot, and awarding hundreds of millions of dollars to investors who are not exactly deserving. So I would stop there, and if there are any questions, I'll be happy to answer. Thanks.
Great, thank you so much, Juan. That's sort of a great effort. We give you a very big task of linking everything we say to the UNCTAD trial working group 3 process. I think you've done a great job. I'm sure that you all know that Juan is one of the leading African litigators on behalf of African states. So when he says in investor-state dispute settlement, so when he says that one of the major challenges is the way that these rules are interpreted, he's talking from experience, and therefore I think he brings a sense of realism to the efforts to reform the process, both at the global level, at the continental level, and at the sub-regional level. And I'm sure I've seen the questions flowing in, so I'm turning this over to BC to start the second phase of our discussion. We have more than half an hour we have 36 minutes for questions and answers, and therefore I hand it over to you, BC.
Okay, thank you very much, James, and thank you very much to all our panelists for such a treat on what is Monday morning in Halifax and perhaps afternoon and evening in many other regions of the world. We have tried to coordinate with panelists while the questions came in, and so we will leave it to their discretion have gotten a number of the initial questions. So we will give you a couple of minutes to go perhaps about 6 minutes to respond to maybe some of those questions. You'll have a second opportunity to respond to them. But if you want to go now, that would be great.
Okay, thank you. Thank you very much, BC. I lost you there for a bit, so I wasn't sure it was me you were referring to. Thank you all for the questions, and I would like to, if you permit me, just paraphrase them as I answer them, so I don't have to read them line for line. I think the first question was related to investment contracts and what we're doing. I completely agree. Like I mentioned in the course of my presentation, ISDS cases emanate from 3 levels, from the BITs, the National Law and Investment Contract. Sadly for us, the P&ID case actually emanated from an investment contract. Internationally, we were trying to do some work on how we can reform those. But given that Nigeria is a federation, we have a center and we have subnationals. A number of these contracts don't only emanate from the federal level, but they emanate from the subnational level. From an investment promotion agency perspective, what we have done is to engage the state investment promotion agencies, more like a sensitization kind of meeting. We've been doing it for a couple of times. I think the last one was about 2 months ago, where we brought to the fore the implications of some of these contracts. We have also taken time to engage the Nigerian Governors Forum to also call their attention to some of the provisions of the contract that will make us susceptible to ISDS cases. There was another question on the ratification of the Nigeria-Morocco BIT. Yes. So short of just letting the cat out of the bag, I would say that most of the work on the ratification of that BIT was done towards the end of last month. And in a matter of weeks, not months, in a matter of weeks, we should all be getting some good news on that ratification. On human rights and environment provisions in the Nigeria-Morocco BIT, we have quite a number of provisions. There are 3 main ones. What the provisions actually entail is to preserve the right of the states to regulate and to raise standards that are at par with the global best practices. Specifically for human rights and labor, we had tied it to ILO principles, and the obligation under the treaty is for the treaty partners to ensure that the standards of their laws in relation to human rights and labor are actually in conformity with what the international best standard is. There's a cross-references to global standards. That's what we've done. And then there was another question. It spoke about sunset clauses, but I imagine that the concern is about survival clauses, because it spoke about the fact that African countries are stuck to treaties even after they want to terminate. What we have done in Nigeria is to take up, we hardly use, our new model does not include any elongated period for survival clauses. Is very, very short. So for the treaties that are already in force, the best we can do is engage our treaty partners. But looking forward, like Hamid had mentioned, if you have a new model, you can now begin to make the changes that you need, and you negotiate on the basis of those changes. So we have definite sunset clauses that bring our treaty tenors to an end, then we can negotiate thereafter. So the question about, and I find it very interesting, about how the capital exporting countries are responding to all the grammar about our reforms. Suffice it to say first that Africa is no longer a strictly capital importing country or continent. We are now both capital importing, and in some cases we're also capital exporting, especially intra-Africa. But to answer the question directly, our experience has been very interesting, to say the least. We have had occasions where we have had pushback from the capital, from the developed countries. I would like to use that word. We have had pushback from developed countries who are like, they are used to African countries taking, almost BITs that have no substance. So they will certainly push back. So it comes back to the country. Are you sure this is what your country needs? For us as Nigeria, we have had pushback, but we maintained our stand. In some cases, we have had to park the negotiations until our treaty partner is ready to renegotiate. In other cases, we've had pushback and pushback until we now finally, when they see that you are serious about the position you have taken, they are likely to sit with you around the table. But the position we have taken is, if you're not likely to sit with us around the table, then there's going to be no movement, because this is our current policy direction. And then finally, there was a question about the publication of Nigeria's model BIT. And the question was referencing the Morocco BIT. I am proud to say that I led the Nigerian team that negotiated that Nigeria-Morocco BIT. And sadly, no, the BIT model is not publicly available. But if you read the Morocco BIT, a number of the provisions you'll find there are what is reflected in our model BIT.
Okay, thank you very much for those responses. You have done them in the order. If there's a model example that would like some of our panelists to follow in terms of the multiple questions that may be posed to them, so that we can respond to all of them. Hamid, you want to respond to the question from Joe, and I'm happy to just read it again for the benefit of our participants, since the scroll function may need to be dialed up to see it. His question was and is, in what way, if any, is the balance between human rights consideration? No, Odi, excuse me. Odi's question is for Hamid. What are the differences between old and new generation BITs? Thank you. That's the question for you.
Yeah. Thank you very much. I think that's an excellent question, because in one question we get to go through the core of the issue we are discussing when we are talking about reform. What are we reforming and for what? But just to give you 3 points or 3 examples of the key difference between your typical old bilateral investment treaty and a new agreement. The difference are the new treaties will typically have more refinements, which means more clarification of previously very broadly drafted provisions, more balance between investor rights and obligations. So you will find provisions that are not only on investment protection. You know, an old treaty, you will find very broadly drafted provisions and 10 pages of investment protection provisions only. And of course, you know that broadly drafted provisions can be interpreted very broadly, again, by arbitral tribunal, which maximizes investment protection beyond control, because any provision, especially, for example, fair and equitable treatment that was in the bulk of the treaties drafted in one sentence. Fair and equitable, each contracting party gives investors of the other party full and equitable treatment, full stop. Of course, negotiators at that point were not anticipating or expecting what's going to happen 20 or 30 years from a treaty they negotiated in the 80s. And we see today that 80% of the 1,000 investor state dispute cases are claiming a violation one way or another of FET. It is a catch-all provision, and so in the new generation treaties, this provision is refined, is clarified by, for example, a specific list of state obligations, and a lot of treaties, or not a lot, but a number of treaties have omitted FET altogether, as we see in the Moroccan and the Brazilian approach, for example, and in some other BITs. The last difference is more focus in the new treaties on environmental, social aspects and the protection of these non-economic issues as you wish. They are included in the new generation treaties with a view to ensure that the state has the duty to regulate. We often talk about the right to regulate, but every state is here to regulate. That's the duty of the country or the government to regulate. So basically more refinements, more clarifications, more balance. And I think this is for the benefit of investors and the state, that they know precisely what are their commitments, what they have to do and what they cannot do. This is the big difference between an old generation BIT, and you can just maybe open any old BIT from the 90s and compare it to the Nigeria-Morocco BIT, just to give you an example. You will see clear differences there. Thank you. Over to you.
Thank you very much, Hamid, for the great response to the question from Odi. Yvan is next. He will be responding to the question from Job, which, to rephrase, it is, in what way, if any, is the balance between human rights considerations and state essential interests sought to be addressed in the new generation BITs? So the questions seem to dovetail each other also very well. So if you have about 3 minutes, that would be great, because there are many more questions on the queue.
Yes, thank you very much for the question. Yes, as you just said, I feel like Hamid's responses kind of already preempt my answer to this question. Human rights considerations are, it's a very broad concept, and then it includes all sorts of matters, be it health matters, labor matters, environmental concerns. So the best way I would say to address these considerations would, as has been said previously, would be to preserve enough sufficient policy space for governments to be able to pass policies in these areas. And then how can that be achieved? As Hamid has just mentioned, this can be done through a number of ways, through new provisions. Some of the new provisions that that sort of tends to preserve the policy space of the states in these matters. I'll just maybe cite one very innovative that we don't see as many in new treaties, which is called the not lowering standards. It's basically it tells states that they should not lower the standards in labor matters or environmental matters to sort of avoid a race to the bottom. So yeah, so that's pretty much how I would answer to your question. Thank you very much.
Thanks a lot, Yvan. Just before we go over to Juan, I do want to say to our panelists, there's a question from Nicole. If you want to just reflect on this while one is responding to the questions, she asked what the speakers feel about the UN binding treaty and how it will impact investment law and practice in Africa. So again, I'll come back to this. If anyone wants to come in, that will be okay. But for now, it is for one to respond to some or all the questions that have been directed his way. One, do you want me to maybe read out some of them to you?
Please, yes.
Okay. All right, I'm happy to do that.
Yeah.
So let's sort of start from spoke about the importance of the lack of clarity of the substantive provisions of BITs and international investment agreements. How can African countries definitively address this lack of clarity? So that's the first side. This other side of it is you sounded skeptical of the proposed reforms, including appellate mechanisms, interpretive bodies and mechanisms of accountability/ethics, which are all process-based reforms. So that's the first one. Let me use my moderator's discretion to also read the others to you so that you respond in about 5-6 minutes to them as a group. There's one from Harrison Mbori, who's asked, for the purposes of dealing with the second problem of unaccountable ad hoc ISDS tribunals, instead of a new investment court for Africa, which he said is unpopular, can the present sub-regional courts or the dispute settlement system of the FCFTA, in particular the standing appellate body, be used for such purposes? He has asked. I think there's one more that I noted, yes, for Kudzai, who said, what are the major objections of African states to the institution of a court, which is growing in popularity, these questions all have overlapping aspects. And so I'll yield to you for about 4.5 to 5 minutes or thereabouts, if you can kindly pull them together. Thanks.
Okay, I can do that. Thanks, Visi. So they actually line up very, very well in terms of substance and procedure. So I'll address them together that way. So the lack of substantive clarity, part of it is because of what Hamid said earlier about in the old treaties, for whatever reason, they chose to limit the words that they wanted to use by saying fair and equitable treatment, and that's it. And the arbitrators were asked to interpret what those things meant. So fair and equitable, anyone can have a fairly good understanding of what is meant in that, but that concept was stretched beyond its limits for a variety of reasons. Part of it is clearly, to my mind, is because of lack of accountability of the decision-making process. In any case, the question, the way it was read to me, says, how can we, minimize this problem? And part of it is what Hamid said earlier, by broadly defining the term, providing an excellent example of that is the Canadian model and also the USMC, where they actually have provided interpretive tools, whether in an attachment form or in fact to just plainly defining it. When you do so, you can say, this is what it means and this is what it does not mean. So that way you can actually provide clarity. That does not resolve all of the problems, because I know clever arbitrators could find a way around almost anything that you say in a substantive treaty. And the key is, I'm not accusing anyone of doing that, but there are specifically oriented arbitral tribunals that want to maximize investor protection at the expense of the state's regulatory power. So if you have those kinds of ideologically entrenched arbitrators and extremely highly skilled people, they always find a way to rule in favor of the arbitrator. So the clarity of the substantive rules does not resolve all of the problems. It minimizes the problem. So that brings me back to the procedural questions that have been asked. What's wrong with a judicial process, a court system with an appellate check, and why are the Africans reluctant not to adopt that mechanism while it's popular in Europe and elsewhere? And I've had interactions with the African Union, Economic Commission for Africa, and as an expert on the draft protocol. And the sense that I got, this is just informational, is that member states were not considering possibility of a court system for investment, at least not for now, and partly because there have been courts, regional courts, and haven't been very successful, so that experience was not very encouraging. But I don't think that the chapter is closed. That I hope that they will consider that at some point. Now, in terms of utilizing the existing appellate mechanism for the continental free trade area, that it requires some very skillful architectural design to fit it into an investment system, because it's primarily state-to-state, trade kind of court that we're looking at. If you want to leverage the infrastructure and to minimize cost, it could be, but investment dispute would fit in very awkwardly if you put it in there for a variety of reasons. So we're looking at investor-state arbitration, and you would have to task that an appellate mechanism that is primarily tasked with the adjudication of state-to-state claims arising out of trade agreements and whatever it is. So although the possibility of redesigning and readjusting and is possible and is in fact being considered, but it is something that requires a lot of careful thinking and see if other alternatives actually are not easier to set up than using the existing one. I think those are broadly, and this is the 5-6 minutes that you gave me, and that's all I can say at this point.
Thank you very much, Juan, for the brevity in responding to those questions. I may have missed one of them. I think I did from Gudrun. It's about the procedural aspect of the UNCTAD Working Group 3, which she says they expressly and repeatedly exclude substantive standards from their mandate. Do you think that ISDS reform without addressing substantive standards makes sense? Do you want to come in a minute on that?
Yes, just a brief minute. So whether it makes sense, it might. And the way I see it, well, they know that agreeing on a substantive treaty at a multilateral level has proven extremely difficult. This has been tried for 50 years, and there's all sorts of theories explaining why that was not possible. A trade like substantive rules on investment has been tried before, and people are talking about it, but now it's not even being considered. So the multilateral treaty they're talking about now is actually pertaining to dispute resolution, not the substantive rules. But does it make sense? Yes, I think the greatest problem with investor state, to me, is the decision-making process, more so than the substantive rules. And the reason it makes sense is if you reform the decision-making process, make it accountable, appellate system and all of that, and that could potentially create coherence in the jurisprudence. Think of the U.S. Constitution, 5,000 words, but somehow a very, substantial and coherent jurisprudence has emerged out of it. So substantive rules are important, but I think more important than that is a disciplined, accountable, and proper decision-making process that could actually explicate, explain, and create jurisprudence around it.
Thank you very much again. So that's great. There are two sets of questions on the table, and I think I'd like to way to go as a way to round off the Q&A sessions, so that we can have some closing words from both James and Hamid, and thank our participants, also perhaps intimate you about some future things coming up on Afronomicslaw.org. So there's the general one, which Nicole had asked on the UN binding treaty, and how it will impact investment law and practice. And I think there's a little bit of overlap of the journey which Nwamaka has posed Patience. So Patience, you can prepare to answer after any or some of our of the co-panelists who might want to intervene on that question have had their go. So I'm not sure if anybody wants to go in on that particular question. And I'm wondering if, and I checked, I hope it's not the case that her internet has a challenge. But Ms. Ngeno, I was wondering if you wanted to come in on any of the questions. This would be a great time. Perhaps my initial intimation was not delivered.
Thank you very much, moderator. I would like to come in on the question around sustainable investment. I think there was a question asked by Kennedy about sustainable investment, and then about how to address issues of indirect expropriation, and how important the reforms or the provisions around this are. And they are very important indeed, because it is around these issues that we are undertaking reform, or countries have actually undertaken reform. If you look, for instance, at what sustainable investment is, and around the sustainable development, when we are crafting our treaties, we craft them around incorporating environmental, social, and governance factors in the treaties themselves. And this is the essence of sustainable investing. Beyond the matter of return on investment, we want to say we want value investment in the African economy. So when we want value investment, we are saying if you want to benefit from this treaty, let your investment, first of all, be value investment, and secondly, let the investment be around these issues of environment. Ensure that you address environmental management, and we have actually put them in our various treaties. When you look at COMESA, when you look at East Africa Community, when you look at the Pan-African Investment Code and some national treaties, they have actually drafted environmental provisions in the treaties. They have drafted social provisions in the treaties where you have corporate social responsibility, and then they have also looked at indigenous people. So you're protecting that as well within the treaty. And then when you come to the threat of indirect expropriation, again, this is the core of the reform that we have, where we have the right of state to regulate. So the right of state to regulate addresses the issue of indirect expropriation, that whatever action that the state has taken, as long as it is for a public purpose, as long as it has been undertaken in accordance with the law, if this action affects the investor, then this action, which is indirect expropriation in a way, should not be taken to arbitration, because this is a right of state to regulate. So it is a center of this. So these are critical provisions that are very important in the reform process of our treaties. Thank you very much.
Thanks a lot, Roselyn. We really appreciate that. So, sorry, this is the thing I don't like to do. We are 9 minutes from ending, and if there's something we like to do is to keep the time in these webinars. So, I don't know if I'll use my except there's a panelist who really wants to speak to Nicole's question. I'd rather go to the very specific question by Nwamaka to patients. And then if there's a response you want to share with us on Nicole's question, we're happy to pass that on to Nicole, if she can provide her email on the chat to us. So patients, do you mind going for about 2 minutes or thereabout, please?
Yeah, I'll do my best, Olabisi. So I'll try to answer Nwamaka's question and a question from Ohio. Nwamaka's question bordered on whether there was some legal competence now for state governments to sign investment agreements. I would like to clarify that what we have spoken about on investment contracts are distinct from international investment agreements, which are treaties. For treaties, those international investment agreements, only the federal government can commit the Federal Republic on those. But we're talking about investment contracts which can be signed either at the national level or at the subnational level. So it's important that we carry the governors along. Your question on the National Action Plan for Business and Human Rights, no, NIPC, it's not under our purview, but we believe that that kind of subject will be dealt by the Human Rights Commission. And NIPC is very open to work on any interministerial or intergovernmental effort on that. Ohio had asked whether the engagement with the Nigerian Governors Forum was to get them, to carry them along or to rein them in. We certainly do not have the competence to rein in the governors. We believe that if we make them understand the need for reforms, they can better support the reforms that the Federal Republic is doing. So our object is to make them understand, appreciate it, and actually become our ambassadors for these reforms at their states. And then for us to also acquaint them with our international obligations at that subnational level, so they are better informed as they move ahead. And there was a comment also about the governors attracting investments on their own. Certainly, we want all investments that are qualitative, of the right quality. We do not fool ourselves to say that the IPA can do it alone. Nigeria is a very large country, but we want everybody to be informed and to do it from an informed perspective. So our object in NIPC is to build the capacity of the states to be able to attract qualitative investment in line with the policy and direction of government. I'll stop here, Olabisi. I hope I did well with my time.
No, you did excellently. You know, it's not often the case. I mean, we've been fortunate with our panelists, but it's not often the case that you have people who really try to contain the wealth of information they have to share. with audience, while respecting time limits. So I do want to thank you all very much for agreeing to be part of what is event. I'll hand over to James and I'm sure Hamid as well for their say before we then formally close this. So please hang on with us for the last 6 minutes for some important pieces of information. Over to you, James.
Thank you so much, BC. That was good moderating. Hamid, do you have a few closing thoughts before we?
Yes, sure. I just wanted to thank you all again, really, for an excellent webinar. Professor Gathii, Professor BC, Professor Kidane, and our dear friends Roselyn, Patience, and my colleague Yvan, and all the participants for the excellent questions. I think we had a very good meeting, and just to conclude, 2 points is that we are in UNCTAD now working on a document that is going to come out very soon, which is called the IIA Reform Accelerator, and that should be very useful to all countries and especially Africa. And finally, an invitation to all of you to join us in our annual International Investment Agreements Conference, which will be held in December virtually. We're still working on the specific times. And of course, our dear friends from Afronomics will get a very special invitation. Thank you all so much, and thank you all for joining us. Thank you, Professor.
Thank you so much, Hamid, and I join you in thanking all the speakers. I will not take much more time except to encourage you, if you'd be interested in perhaps putting down maybe 1,000 words that we can post on the blog to reflect these discussions. I mean, we hadn't spoken about this, but that's just a thought. We certainly delighted that the conversation really went very well today, and that we shall continue this conversation, especially with UNCTAD. We're delighted about this collaboration. So a few things coming from Afronomicslaw. This week, we have entered the 3rd week of our symposium on teaching and researching international law global perspectives, with our collaboration with the Center for International Law at the National University of Singapore. So check that out. Next week, we will sort of be digging deeper into this sort of large area of reform by looking, by having on the blog the symposium by Professor Titilayo Debola on intellectual property rights, global rules, regional and local realities, which was a webinar a couple of weeks ago. In November, we have a webinar with UNDP Africa, so look out for the announcement about that. We're also going to be posting our latest Indaba, the 3rd Indaba, which is a conversation with Dr. Joy Kategekwa, who is now at UNDP New York, and it's sort of looking at the AFCFTA and its future and the implementation challenges and prospects. And then we're going to have a symposium at the end of October on 60 years of independence in Africa, a symposium responding to an article on decolonization 60 years later by Dr. Ian Taylor. And finally, the African Journal of International Economic Law will be launched very soon. Tons of articles there about international investment reform in Africa. And so look out for that. It's going to be completely free, very high quality articles. And we are really looking forward to that. So thank you everybody for being here today. And to our speakers in particular, we are delighted that you made time for this discussion. And we look forward to further collaboration with all of you, and have a very good rest of the day, everybody. And see you all very soon.